In this video, we'll be going over the relationship between intellectual property rights and conceptual art. Think of art, what is it that comes to our mind? Probably famous paintings that we've heard of or seen in museums. For instance, imagine walking through a museum. These are the kind of images that you would see in famous museums such as the Guggenheim or Le Louvre. Walking through a beautiful museum filled with so many renowned pieces of art, and then you see different pieces like this: limbs on a ladder, a picture of a chair, alongside a definition of a chair, the backside of horses hanging from a wall, or a picture of a pipe saying this is not a pipe. While these are very unique, does this come under the definition of art? These pieces are called conceptual art. So, what is conceptual art? Conceptual art is a branch of contemporary art. Unlike other art scenarios, the idea or the concept is more important than the finished product itself. Unlike traditional art, whose bedrock is aesthetic, technique, and expression, conceptual art tinkers with painting as an idea. It is an art of the mind rather than of the senses. Conceptual artist Lewitt was a leading proponent of conceptual art, which he famously explained by saying that the idea becomes the machine that makes the art. In this way, the artist conceives of the art, which is then made by other hands and then is self explanatory. He famously stated that when an artist uses a conceptual form of art, it means that all of the planning and decisions are made beforehand, and the execution is a perfunctory affair. The idea becomes the machine that makes the art. Conceptual art is now increasingly recognized. However, with conceptual art, seeing the picture is not the same as getting the picture. Conceptual art is not just what meets the eye, it's an extension or reflection of the artist or creator. Through idiosyncratic expression in portraying an idea, fleeting feelings or emotions, or distinctive themes, no two creations are the same. Conceptual artists believe that the art is created by the viewer, with features of self and the viewer's life as an interpretative tool. The beginning to end of a viewer's interpretation of the creation is the art, and not the artwork in itself. This work of art, for instance, by Joseph Kosuth, is pointing out the existence of things in time and place. Here, there's a dictionary definition that's used as a verbal sign that points to something in the world. And we have a photograph, which is a visual sign that points to something that is or used to be in the world, and an actual chair. Which of these three chairs do we perceive to be more chair than the other? Especially now that the real one is in a museum and will likely never be sat in again. John Baldessari stated that conceptual art wasn't about the art that had a concept, but about interrogating the concept of the art. No singular style or form of conceptual art. It can take whatever form the creator deems most appropriate to give life to the idea. The purpose of conceptual art is to connect to the viewers. The method of artistic expression and the scope of discourse are infinite. It is the very nature of conceptual art to be like Louis Cheshires' cat, elusive and slippery. Over the last century, Indian art has seen vibrant flourishing of creative practice. Like all creativity and innovations, this too comes under the protection of intellectual property rights. However, Indian copyright law is not accommodative enough to incorporate artists' spatial arrangements of elements consisting of artistic and cultural thought processes. Conceptual art is met with great popularity commercially. However, it falls behind in the realm of legal protection. IPR is a means of safeguarding and rewarding creativity. This is important for artists to ensure rightful recognition. Under the present copyright legislation in India, protection is provided for works where the idea is distinguishable from the expression of the idea or the final product. Conceptual artwork is not covered under this umbrella. In India, it is only the finished product, that is, the expression of the idea, that receives protection. Ideas in itself are considered too valuable to be monopolized. According to Section 13 of the Copyright Act of 1957, protection is granted to original literary and dramatic works, cinematographic films, sound recordings. This right is given to derived works and not to a novel idea alone. Thus, copyright protects the work of a creator and prevents unauthorized utilization and reproduction. However, there is no bar against another creator coming to the same result by an independent process. Thus, the idea is not copyrightable. It's only the translation of the idea which receives copyright. The reasoning behind this parameter of Indian copyright is to ensure the unrestricted flow of ideas. Copyright of ideas would be hindering creativity and innovation. Freedom to use ideas is essential to the foundation of copyright law. Thus, idea expression dichotomy doctrine was postulated to ensure that it was the exposition of an idea that was protected as opposed to the idea in itself. This doctrine is faced with the complicated obstacle of separating idea and expression. This is widely used in the United States and is also no stranger to the Indian jurisprudence. The earliest case dealing with idea expression dichotomy was the US Supreme Court decision in Baker versus Selden. According to the facts of the case, the two men had made an improved version of bookkeeping. However, both were achieved by using different methodology. The court held that while copyright protects the sale of a book, this protection is not extended to ideas and art in the book. This is the first case where a clear distinction was made between idea and expression, and was founded on the fact that otherwise it would be providing undue monopoly to respective copyright holders, which would result in anti competitive practice. Nonetheless, not all ideas can be expressed creatively in a myriad of ways. That is, some ideas might only have a singular creative expression. In this scenario, copyrighting the expression of the idea is synonymous to copyrighting the idea in itself, and this would lead to stunting the free flow of ideas. Thus, where the expression of the idea is one with the idea, the merger doctrine is applied. This addresses the point where idea and expression converge, and such expression of idea will not receive copyright protection. For instance, in the case of Morrissey versus Procter and Gamble Co., it was held that rules for a contest is synonymous to the idea behind the contest, and thus it cannot be copyrighted. Similarly, in the case of Joshua et Hodkin versus Sky Spirits Inc., the question before the court was whether photographs of the iconic blue bottle of Sky Spirits could receive copyright protection. The court took the stance that there are only a few ways in which a bottle can be photographed, and thus it cannot seek copyright protection. The merger doctrine would undermine effort and time invested by the creator. In the above mentioned case, the photographs in question may not exactly be the same. The slightest variation can result in a whole different point of view. In situations like this, the idea expression dichotomy is inadequate. Conceptual art is balanced on a thin line between tangible protectable creation and unprotectable idea, which forms the core of artistic work. This art is largely based on reinvention and recharacterization, which would include elements from a pre existing pool of knowledge. At what point does the right of one artist end and the rights of another begin? Perhaps the test of substantial similarity may be used in examination of the degree of uniqueness of the new work. Each case would have to be evaluated on its own merits, as a fixed set of rules would be redundant. Some viable solutions could be to assess methods where merged ideas and expression can be evaluated and the merger doctrine needs to be reassessed. And IPR for art, which is an ever changing field, should include novel ways of incorporating converging ideas and expressions. Contemporary art or conceptual art cannot be dealt with using these obsolete laws. However, due to continuous modern art movements in India, things are expected to change, and the scope of copyright law might expand.